Welcome to Pass Law Exams, your go-to channel for mastering contract law, one topic at a time. Today we are covering part 1 of a 2-part video on consideration. Let's get to it. Imagine a man promises you a car for free. You are excited, but legally, that promise is worth nothing. Why? Because you gave him nothing in return. That is the rule of consideration, and today we are breaking it down. In Currie v. Misa, 1875, Lush J defined consideration as, write this down, a valuable consideration, in the sense of the law, may consist either in some right, interest, profit or benefit accruing to the one party, or some forbearance, detriment, loss or responsibility, given, suffered or undertaken by the other. Quote that in your exam, and watch the marks come in. Viscount Haldane, L.C. in Dunlop v. Selfridge, 1915, adopted Sir Frederick Pollock's definition. Write this down too. An act or forbearance of one party, or the promise thereof, is the price for which the promise of the other is bought, and the promise thus given for value is enforceable. 2 definitions. 2 cases. Your examiner will take notice. Consideration comes in 2 forms. Executed consideration is an immediate exchange, money for goods, right there and then. Executory consideration is a promise to do something in the future. For example, I will deliver these goods next Thursday. In a wholly executory contract, the making of the promise by each side is consideration for the promise made by the other, as confirmed in Dunlop v. Selfridge, 1915. Now, consideration must be sufficient, but need not be adequate. The courts will not ask whether you got a good deal. They simply ask, was something given? In Thomas v. Thomas, 1842, £1 per year was sufficient to support the right to live in a house. In Chappell v. Nestlé, 1960, even 3 chocolate bar wrappers counted. As Lord Somervell put it, a contracting party can stipulate for what consideration he chooses. Thomas v. Thomas shows what is sufficient. Chappell v. Nestlé pushes the boundary further. Finally, consideration must move from the promisee. In Tweddle v. Atkinson, 1861, 2 fathers agreed to pay money to the groom upon his marriage. The bride's father died without paying. The groom sued and failed. He was a stranger to the consideration. If you did not provide it, you cannot enforce the promise. This is a simple understanding of consideration. Applying it to problem and essay questions requires finesse and skill. Head to passlawexams.com for past paper questions and answers. And before part 2, consider this. In Currie v. Misa, Lord Coleridge CJ dissented, arguing a pre-existing debt cannot be fresh consideration. Was he right? Find out in part 2. Existing obligations, past consideration and promissory estoppel. Don't miss it. So, to pass your contract law exam on consideration, identify whether consideration is sufficient, ensure it moves from the promisee, and ask whether it is past, present or future. Want to test your knowledge? Visit us at passlawexams.com for past paper questions and answers. Subscribe to Pass Law Exams for more tutorials, and visit passlawexams.com for full study support. Pass Law Exams, because passing is the only option.